Here's what we're going to do tonight. We're going to go back. We're just going to quickly review a couple of things that we finished up with on Thursday night. Basically talk about the contracts. And we're really into contracts now. This is important, how these things shape up, because this is your lifeblood. How to interpret them, how we write them, who can write them, things of that nature. And then as we move along and finish chapter 9, we're going to roll into chapter 10. We're going to do a pretty comprehensive review of our Form 2T contract. Just from the beginning, very quickly, we talked about bilateral contracts, which means we have two parties, a promise for a promise, right? We talked about unilateral contracts, which is one party made a promise, the other party has to act, right? So maybe I have an option to purchase, or maybe I have due diligence money. The seller would still have to sell it to me if I come back, but if I just let it go, I can walk away at any time. So that's a unilateral contract. That's just singularly one. We also talked about executory and executed contracts. So executory is once we have a signed contract, there is still some things that have to happen. Now you'll hear it called executed, but at the last signature and the last set of dates, it's not. All right, it's not. It's just normal. That's what they call it. That's what we've had over the years have called it. You're not completely executed in a contract until everything that was in that contract is done. So that means that all of the inspections are done, all the money's changed hands, all of the walkthroughs, everything. That's when we close on that. Okay, when it's closed, that's when it's executed. But until then, it's executory. There's things that have to be done inside of that contract, all right? All right, so we talked about valid contracts and void contracts. Valid contracts are enforceable. They could be voidable by any one of three measures. If they are, somebody's a minor, they can still get in a contract, but they can void it at any time. If somebody is under the influence of alcohol or drugs or anything else, they sign a contract, they can get out of it if they can prove that they were under the influence and did not know what they were doing. But maybe they do, if we can't stop them from buying or selling. And then the third one is if they're under duress. Somebody's forcing them to do so. If they can prove any of those things, it is voidable, okay? It is voidable. Now, it has to be in writing. Contracts have to be in writing, all right, to be enforceable. If it's not in writing, if it's just in verbs, just in words, it is unenforceable. We can't make it happen, can't prove it. And that's the hard part. We also talked about void contracts. So we needed four things to make this valid. The first one, we needed competent parties. The parties had to be competent. The second one was we needed consideration, okay? We needed some sort of valuable consideration. Otherwise, it's just a gift, okay? The third one is we need agreement between the two parties, right? We need to have a promise, I promise, you promise, right? And it has to be for a legal purpose, all right? So we need consideration, we need agreement, mutual assent, we need it for a legal purpose, and the parties have to be competent. Right. Those are the four considerations for a valid contract. A void contract was never enforceable because it didn't have any of the legal elements. It didn't have any of those four things. So it can never be enforceable if it's void. It simply goes away. Go to in front of a judge and he's going to say, go away. I have no jurisdiction here. You're missing something. You're missing a legal party. Or you're missing consideration. This is just a gift from one person to another. It's not a contract, it's a gift. That is why we need those four elements. So just as an example here, void or voidable, a buyer who is voluntarily under the influence when they sign the offer would render the transaction voidable by the buyer, but not void. Maybe I'm happy I'm buying a house. Maybe I went out and got a few too many drinks in me because I was excited. That doesn't mean I shouldn't be able to buy the house, right? So in that particular case, we just launch into it and we say, all right, hey, yes, I was drunk when I signed the docs, but I'm good. I still want to buy this house. And you want to go forward at that extent. Now, if you are underage and you buy and sell a house, If you turn 18, which is the age of consent, you no longer can void the contract, okay? So if in the middle of that contract you turn 18, you can no longer void it. And it can never be voided by the other party. So if we have a 17-year-old we got into a contract with, I have no right to void the contract. I am of legal age. I knew what I was doing. They're not, okay? They are not. They can revoid it. They can void it. We can't. So consideration has to be an exchange of something valuable. It could be money. It could be property. It could be inventory. It could be stock. It could be anything valuable. All right, anything valuable, but it has to be valuable to exchange it. All right, and that is consideration. I will give you $500,000 for your property. You will give me the title to the property. That's what the deal is. That's the promise for a promise. Mm-hmm. Just because we've got a contract, if we don't record it, it's still valid. It's still a contract between two people, and it's in writing. It has to be in writing. It's still valid, okay? And we can get it enforced, even if it wasn't recorded. And it requires at least two legally competent parties. So we have to understand what we're doing. And that's the goal. We're going to talk about the reality of consent, which is the next slide, okay? The reality of consent is that you understand what you're doing, okay? There's a couple of little sequences to it, but I want to buy a house. I understand that. I want to sell a house. I understand that. And this is all the things that it brings. So there is no surprises. We understand each other. We have a handshake, all right? So as long as we have that reality of consent, we have it. All right, we have a contract. And again, it has to be supported by legally sufficient consideration. The reality of consent, there must be no duress. You can't be under physical harm to purchase or sell. Nobody can be holding a gun to your head, okay? You can't be under undue influence, the threat of emotional or mental harm. Your spouse says, if you don't do this, we're going to get divorced. I'm leaving you here out in the street. Okay. So that is duress, right? Somebody threatens you with any kind of anything, right? Imagine your worst fear. Well, that's undue influence, right? You would do anything. And you also have to be very, very careful of misrepresentation. So if somebody lied or somebody doesn't tell you the whole truth, you don't have the reality of consent. If I told you that building never flooded and it does flood, you consented based on the fact that that building never flooded. All right. So there were no illusions. And I created an illusion by telling you it never flooded. It was a lie. All right. So that's misrepresentation. And then fraud is the next level of misrepresentation. That's willful deceit. All right. That's willful deceit. And if we commit fraud, then we don't have the reality of consent. And obviously, we're going to get sued pretty severely. It's tort liability. Let's talk about how the documents flow here. 95 times out of 100, the buyer's agent and the buyer are going to make the offer. Okay? Maybe even 99 times out of the 100. So I'm going to write this offer, this 16-page offer that we'll see later on. And I'm going to send it to the seller, seller's agent. Now the seller can do one of three things here. And that is he's going to be able to accept the contract as it's written, sign it, communicate it back and say, we accept it. That happens on occasion. They can reject it. They can send it back to you and say, hey, you know what, come back when you're serious. All right, and just send it back and say no. They don't have to counteroffer. And then the third thing they can do is counteroffer it. Now, here's the key. If they accept it, you got a contract, right? As written. If they reject it, there's no contract. They're not going to do anything with it. They just send it back. If they counteroffer it, if they offer so much as a change in 1 day or $1, it can be anything. If they make a change to that contract, it automatically rejects the first offer and it becomes a new offer. So if I go to James and I say, James, I'm going to offer you $300,000 cash for your house, 30-day close, no contingencies, no inspections. Close 30 days from now, which is February 17th. And James says, wow, thank you very much. I think I like that a lot, but I'm not going to be in town on February 17th. Can we move it to February 18th? And he takes my contract and he changes it from 2/17 to 2/18. And he sends it back to me with signatures on it. He's created a counteroffer that I do not have to accept. I can just simply walk away. Say, thanks, I appreciate it, buddy, but I'm not, no good for me. I'll offer you less money. All he's got to do is change one day or $1. All he has to make is a simple change. All right. So that creates a new offer. And now he is the offeror and I am the offeree. Originally, me as the buyer is the offeror. I am giving an offer. Seller is the offeree. Because the seller rejected it or changed it, now he is the offeror coming back to me. I'm the offeree. And I don't have to accept it. I could do, and now it starts again. If you notice on our sheet here, that counteroffer starts again. The buyer can accept it, they can reject it, or they can make another counteroffer, which in that case rejects this counteroffer and starts all over again and keep going. We can accept it, fantastic. We can reject it and just tell them go away. But if we take an offer and we change it just the slightest bit, it creates a new offer and the original offeror does not have to accept it back. All right. That is now a new offer. Rejection of the first one. Now, I go to James, or James comes to me and says that, all right, look, I just need to settle on February 18th, not February 17th. And I say, nah, you know what? That's no good for me. The minute I get that, James cannot go back and say, all right, never mind. Let's just go back to the first offer. Once he sent me back that change in that second offer, that first offer disappeared into the wind. It is gone. We cannot go back. Now, I can make a counteroffer again, changing the date back, but that first offer, we can't go backwards. Assume that first offer is written in sand, and when he writes the second offer back, the first one blows away in the wind. So we may not go back. All right, it goes away. So that's something you might want to remember. The counteroffer kills the original offer, makes it go away. All right. Communication is critical. And if I speak to the buyer's agent, it's the same as speaking to the buyer. If I speak to the seller's agent, it's being told to the seller. Okay, so that is communication. Right. Now, all offers have to be presented immediately, but you have 3 days. If I send James an offer for his house for $500,000 and somebody waits 3 days before I hear back, I got a secret. In those 3 days, I can withdraw my offer. I can just walk away, call him back and say, yeah, you know what? Never mind. Found something better I like down the street. Wouldn't I be better off if I just had it given to him immediately? Let him accept it or reject it, and then let me know where I stand? If he accepts it and calls me back and says, I accept it, I'm stuck, right? I'm in. I can't withdraw at that point. So this 3-day thing that they give you, be careful. All right. Immediately is better. Time is of the essence with these things. You don't want to wait. And believe me, if I'm the buyer's agent or seller's agent, you want to call late and you're going to tell me we got a deal for $500,000, I'll be happy to take your phone call at any time. Right? I'll be happy to get it. So don't worry about hurting somebody else's feelings. We don't care about that. Anybody else be sad about getting a $500,000 offer at midnight? I don't think so. This was happening a lot. What happens if we get multiple offers? If we get multiple offers and I'm the listing agent, I have to present all of those offers in any order as soon as possible. immediately, if not sooner. All right. We have to show them all the offers. We cannot give them one offer, make them decide yes or no, then give them the second offer, decide yes or no, then give them the third offer. You got to give them to them all together so that they know. All right. And so that you can compare. And again, no later than 3 days, but immediately is so much better. We're also allowed, if we get into a contract, to take up backup offers. We can take up backup offers. Right? Yes, we're in a contract right now, but we'd love to have you as a backup offer because deals fall apart. And with due diligence, they fall apart more frequently than without due diligence. So it's something that we can work our way through. All right. So again, all multiple offers in any order immediately. Immediately. Something that's not said here and should be said here. Rule number 1 as a real estate agent, as a listing agent in particular, you must present all offers. That is rule number 1, line 1, section 1. If you get an offer for the property for your client, even if it is a bogus, lousy offer, you must present all offers. So you start out by telling them when you're at the listing meeting, look, don't shoot the messenger, but if we get an offer, I have to give it to you. And if they say, don't show it to me if it's not this, you got to say, hey, the law says I got to show it to you. You can laugh at me and we can reject it. That's fine. But I have to show it to you. And you have to have the opportunity to counter it or do whatever or reject it. You cannot bind your client. So you must present these offers. You must present all of them, even the bad ones, even the one that offered James $175,000 on his $500,000 home. And then you just have to say, all right, look, I'm going to show it to him, but he's not going to accept it. And then we'll hand it back to the buyer and we'll say, come back when you're serious. Okay. And we have an offer rejection form that shows that I presented it to make sure that I did my job. Oh yeah, you can counteroffer the bad ones. You can actually counteroffer at full price. Counteroffer it back at, you can counteroffer at anything. Sure, absolutely. And a lot of times that's what will happen just to show that we've done our job. If something's not very good, we counteroffer back at full price at listing, whatever's in there. And then tell them that, look, this is what we'll accept, which is what's in the listing. And then at least we have documentation. It says, we saw your offer, it was junk. Here's what we really looking for. Somebody wants to see how far you'll move. Maybe you're desperate. Here's the other side of that coin is if you're the buyer's agent, you're supposed to counsel your buyer about that. But if the buyer insists on making a foolish offer, you have to write the offer. They're your client. You have to write it. You can counsel them. You can tell them what you expect. You can tell them to be serious. But let me ask you a question. You might have been in this position before. Maybe James was in this position before. $500,000 house that he wants to sell. Somebody offers $375,000. Is James going to take that buyer seriously at any particular point in the future? No. That buyer, unless that buyer comes up with more than full price money at this point, is James going to negotiate them in good faith? No, because he thinks he's a fool. So all you're going to do when your buyer makes bad offers, all it does is make the seller mad. Now your seller is going to entrench himself and say, you know what, you're a fool and you're wasting my time. I'm not giving you a break. I'm not going to negotiate with you. I know what my price is, it's full price. Now, somebody else, you're not stuck because somebody gave you more money. Terms count too. Maybe somebody else comes in and you take a little bit off the top because they were serious. But if you make the seller mad, it's going to be very, very difficult to negotiate. And you got to let your buyer know that. Because if they think you're wasting their time, then it's just, they're going to dig their heels in and it's not going to happen. So that's why it's important as the buyer's agent to make sure that the offers are serious. Okay, everybody wants to get a little bit off the top. I get that. But don't make a fool of the seller. It's just going to people are going to dig their heels in. And it's not going to work, right? You're going to waste your time. Methods of communication. Communication of acceptance by any acceptable method. All right. Before we go there, there's something here that is not spelled out the way it should be. Let's say let's say Reagan's James's agent. And I send over Tyler's offer to James for $495,000 and cash closing 30 days, everything else. A great contract. And I send it to Reagan, and Reagan sends it to James, and James signs it, sends it back to Reagan, and says, Reagan, I love this contract. Let's go to closing. And they say, all right, good, sign this. Reagan calls back a day later. Maybe she's going out on the town with her significant other. She gets the offer back from James. She's going out of town on a significant other. She's going out for dinner, so whatever. Life gets in the way. So the next morning she calls me up and she says, Sam, I got something to tell you. And I say, Reagan, I am glad you called, because Tyler has found another house and we just want to withdraw our offer. And she says to me, man, I'm sorry, but he already signed it. He accepted it. Who's in the right? Anybody want to guess? Yeah, no contract. No contract. Because when they accept it, that's one thing. They have to communicate it back to the offeror to say they have accepted it. So James says, yes, I'm taking it. I'm signing it. Let's go. Reagan gets the document, but it's up to her now to call me, email me, text me, and say, Sam, we got a deal. Now, the minute she says that, then we have a deal. I can't go anywhere. Tyler's stuck. And we want to be able to make sure everybody knows. But lacking that, even if she initiated the call the next morning, if I say the words first that we're going somewhere else, no contract. We still don't have communication that James took the offer. Okay? That's why communication, remember, time is of the essence, right now. Right now. Yeah, all over the place, we're telling you 3 days, 3 days, 3 days. Can you imagine if Reagan took 3 days to tell me that they accepted that offer? What are the chances that something else is happening? Right now, because Tyler hasn't heard back in the last 15 minutes, is that any buyer, they want to know right away, right? Let's go, let's go, let's go. I want to hear. Am I stuck? Am I looking? What am I doing? I made a great offer. And even Reagan can take 3 days to get back and still be within the realms of the law. But in the meantime, nothing else is stopping. My client is itching to find a house. He's going to keep looking. Therefore, when we find another house, I'm going to call Reagan back in 2 days and say, hey, sorry, I haven't heard from you, but I want to withdraw my offer because Tyler's found a new place to live. And she's had James's signed acceptance for 2 days now. Nothing wrong. She didn't do anything wrong. She's still within the realms of the law, but she don't have a deal. So you see how important it is to communicate. Now, my friends, it's 2023. We have faxes. We still have faxes. They're going away, but we still have them. We have scans. We have texts. We have copy machines. For $500,000, I'll hand deliver it. We need to communicate immediately. And communication can be a simple text to me from Reagan to say, hey, we accept. We love the contract. Thank you very much. Let's go to closing. And then she can send me the docs the next day or whenever she wants to fax them over. Scan them in, send them over. But the communication is, we accept. That's the key. Right? So those are the kind of things that's important. That piece is important. And we don't mention it enough here. So now let's tweak it a little bit. Tyler and I wrote the contract and we said, well, you know what? Let's use the mailbox rule. Let's assume this is 1960 and we're really using the mailboxes a lot. We don't use mailboxes too much anymore, right? Mostly junk mail. But I can, and it still exists, the fact that I'm writing this contract for Tyler, and we say we don't want them to communicate back to us by text or fax or anything else. We want them to sign the bottom of this contract and drop it in the mailbox no later than tomorrow at 6 p.m. We want it postmarked back. As the offerer, we have the right to tell you how we want communication back. Okay? We have that right to tell you that. When I tell that to Reagan, and James accepts it, gives it back to Reagan, once Reagan drops that in the mailbox, she's going to give it to the post office worker. She's going to get a receipt for turning it in. That becomes the delivery. As soon as it's in the hands of the United States Parcel Service, that becomes the delivery. Because we have no control over how long or anything else like that. So she's got a receipt for when she handed it to the person behind the counter. It's before 6 o'clock tomorrow. That's delivery. That's communication. That's notice. All right, that's called the mailbox rule. You can accept a contract via the mailbox rule. You may not reject it via the mailbox rule, okay? You can only use it to create the contract. Now, are we using the mailbox a lot lately? No, just know it can happen. Just know it can happen, all right? So it's considered delivered when it's dropped in the mail, not when it's delivered back to me and Tyler. Now, emails are what? Time stamped, aren't they? Time and date stamped. So if they accepted it, Reagan accepted it, Reagan gave it to James, James accepted it, Reagan sends me an email back within 5 minutes and says, Sam, we accept. That's and I'll send you a copy of it as soon as I scan it in. Once she sends me that email that says we accept, that's mail. Whether I get it in the morning or I get it like 5 minutes after she sent it, it doesn't matter. It's timestamped. She sent it. So that's like electronic mail, same way. Okay. So again, doesn't matter when I get it. It matters when she sent it. Okay. And that's electronic. Scans, anything else like that. It's all date stamped. She's got proof of it immediately. All time and date stamped, everything that's sent, so you can find everything that you need. All right, so we can use e-signs. James doesn't have to sign it with wet signature anymore. He can just point and click, right? Do it electronically. Sign it, send it through DocuSign or .loop or Zip Forms or whatever the one du jour, whatever one you're using. Okay, let's introduce to you the Statute of Frauds. Back in 1677, believe it or not, I think it was King James, if I remember correctly. I wasn't there. I was pretty young, but I was somewhere along the line. He used to hold court. And what was happening was he would solve disputes against people. But he found that the most fraud that he found were people who were fighting over land. That acre is mine. That fence belongs to me, whatever. These lords fighting over that. So his word was good enough with some of these others when they were settling about giving him 3 pigs to make up and 2 pigs and a cow and all of that other stuff. But when it became problematic with land, in 1677, they created this thing called the Statute of Frauds. And the king said at the time, I will not discuss any land deals unless they are put in writing and signed by both parties. Fast forward 350 years later, we're doing the same thing. Nothing is valid unless it is in writing and signed and dated by both parties. This law has lasted 350 years. It's called the Statute of Frauds, and that's what makes it enforceable. Okay, that's what makes it enforceable. North Carolina Real Estate Commission says all real estate documents must be in writing and signed, which includes deeds, contracts, mortgages, any options, any easements, leases. Oh, leases longer than 3 years, right? Leases longer than 3 years. If you have a lease for 2 years, you don't need it to be in writing. It can be oral. All right, but longer than 3 years or longer, it needs to be in writing. Okay, so all these things need to be in writing. If we don't have writing, can we go to the court and say, oh yeah, you know what? I said that I was going to give James $475,000. He said yes, and then James says, no, was he crazy? It's him against me. The judge will say, he'll pat me on the head and say, tell your story walking. Where's your documentation? I don't have any. Have a nice day. You got no leg to stand on. Everything boils down to this. No docs, no case. Right? We need it done. It has to be in writing. So this is called the Statute of Frauds. So now we got into this contract. Now we want to get out. So there's some ways to get out. We can perform, go to closing. Buyer gets the keys to the house, seller gets the money that the buyer promised them, the real estate agents get commission, the documents are recorded, everything is closed, everybody's happy. At that point, contract's over. We did what we said we were going to do. That's it. So it's fully performed, right? Everybody's done their thing. So when that property is sold. What about something that says, you know what? We're 5 days from closing. And the seller, it's an older house near the waterfront, but the property is where the value is. And a lot of this beachfront property is not so much the house, this old rickety house, but it's the property. And a hurricane comes in, and like the three little pigs, they huff and puff and blow the house down. Now we just have this piece of land here. If I'm the buyer, the house blows down that I'm going to purchase, and the seller says, I don't have anything to sell. As the buyer, can I accept the insurance proceeds and the land? What was I going to do the first thing to that house anyway once I got the land? I got to bulldoze it anyway, right? So the good Lord just helped me out. So in that particular case, that would be partial performance. I'll take it. We can go to settlement. I'll give you the money. I get the land and any insurance proceeds that you're going to give me, and I'll take it just the way it is. There you go. Partial performance. The land, in a lot of cases, anything that's close to the beachfront, if it's not a newer house, if it's an older, you know, the old bungalow style houses, the land is worth more than the house. We used to do that all the time. Yeah, absolutely. We used to do it all the time. People would buy these houses and then just bulldoze the house because they wanted the land. The land was worth so much more than the house. So that's what happens in partial performance. Maybe I still want it, right? I'll take it. Material breaches, a couple of things. First, if a seller backs out or if the buyer backs out. Let's say the buyer backs out first. We get close, we've done everything, and we're a week away from closing. Buyer says, I don't really want to buy this house. The seller is going to get his earnest money. He's going to get to keep the buyer's earnest money for breach of contract. Those would be liquidated damages, and we'll see in the contract about liquidated damages. All right, that's the seller's going to get that money. All right, and if it's significantly more than that, he can sue for other things for more compensation if he can prove that it's more than what the earnest money is. So that's a material breach. But what about the seller? What if we're 5 days? What if we're 10 days away from closing, and the seller decides he's not selling? Uh-oh. Buyer spent a lot of money, right? Buyer spent a heck of a lot of money in due diligence money. He spent inspection money. He spent appraisal money. He's probably spent moving money, all of that stuff. Seller comes in and says, I don't want to sell. Never mind. Never mind. And we say, oh, no, that's not going to happen. Well, there's two remedies that could possibly happen for the buyer. The first remedy is that the seller, if the judge says this, if the buyer doesn't still want the house, the seller can stay in the house, but the seller would have to pay the buyer back his due diligence money, his earnest money, all of his inspection money, his appraisal money, anything that he's fairly spent to buy this house, the seller's going to have to give it back to him. The second and probably the most common thing is the judge could say, remember back in second night of class, we talked about the physical properties of real estate, right? Remember the physical properties? Things are immovable. Land is indestructible. And what's the third one? Does anybody remember what the third one is? Physical characteristics. It's indestructible. It's immovable. What's the third one? It's unique, right? So that means that that house is different than any other possible house, even if they're next door. It's different. If I'm the buyer and I want that house, I can go to court and I can say, Mr. Judge, it's not fair. I want that house. I can see out the window for whatever reason. Okay. And the judge can do what's called force specific performance, which means that Mr. Seller, pack your stuff. You have to sell. This buyer's in good faith, done everything he's supposed to do. He wants that house. That house is unique from all others. Mr. Seller, carry on. You have to sell. And the buyer gets to buy the house through specific performance because that house is unique. So yeah, as a buyer, you can go to court and get that. All right, so that would kill your contract also. That's a material breach by the seller. Still have a couple more. Termination by default versus termination for convenience in my world. There is also a couple other ways. First one is what? We have impossibility of performance. If the buyer can't get the loan, can he buy the house? No, right? If the seller gets foreclosed on or bankrupt or anything else like that, can they sell the house? No. If the seller can't deliver clear title because it's got so many liens on it, right? So he can't sell it. Again, can't perform. So all of those things. Now they can still be held in breach of contract, but if you can't sell, you can't sell. If the buyer can't get funding, he's going to lose his due diligence and his earnest money, but still can't buy the house. He's not going to get it. Doesn't have the money. Operation of law. If the law says you can't sell it, what if it's going to be taken over by eminent domain, the piece of property? Law says, so we're going to tear that house down. We're going to make a public roadway through there. Can the law stop it? What if you haven't paid taxes and you still have a lis pendens out there and the government says, we're going to put a lien on that property. You can't sell that property. We're going to take it. We're going to seize it. Can they do that? Yeah, they can, right? So those are all operations of law. Or how about this? You're under arrest for failure to do whatever. Can they stop your sale of your house? Yeah, you can. Okay. True story. I had a lady who listed her house. She was divorced from her husband, but they never really, they always kept the house together. She never gave him power of attorney. She signed the listing docs and everything else. And then we listed the house, we found a buyer, and we got a good contract. And then we go to closing and we can't find her. We're in South Carolina now. This is a South Carolina house. Turns out the week before the closing, she had been put into a special facility for the mentally insane. You'll hear all of these, and this is true. So what happened was we wanted to, she needed some rest. We needed the documents signed so that we can finish the closing. Good close, good. We had a good close, we had good buyers, we had good sellers. We just needed her to sign the documents. And her husband didn't have power of attorney, so we got him to sign the documents. We needed her to sign the documents. She was now in Florida in a rest home, if you will, trying to get some relaxation under supervision. And the truth of the matter is that we tried to get through to the doctors, and the doctor says she cannot have any outside visitors for the next 30 days. I still don't have a closed deal. We tried every day her husband was in there. There was no dispute that we wanted her to, and she was going to sign the documents. But the problem was we couldn't get to her. The doctor would not let us in the door. So we had to wait. We had the buyers, the attorney said, all right, let the buyers move in. We know that this is going to go. But she could have changed her mind. She's in the rest home, if you will. But what if she changed her mind? Or what if she becomes completely haywire? We would have buyers. The buyers were scared to death that they were going to lose the house. They were going to move in and lose the house. And we're trying to convince them, hey, she's going to sign the docs. We just have to get to her. And her husband went every single day. And then ultimately, after about, I would say we were 17 or 18 days in, then finally the doctor let her out for like 5 minutes so she could sign the documents under, we had to do it with a notary and then take them back. So the buyers were literally in the house for 3 weeks before that we could close on the documents. Things like that happen, right? That's life, that's people, that's what happens. It's a pretty easy job until you mix in people. And then once you mix in people, it gets really complicated. Yeah, that's a true story. And when you're her psychiatrist or you're her, whatever that doctor is, and they got, patient privileges and things of that nature, and that's their treatment that says nobody talks to her for 30 days, good luck getting in the door. Of all my real estate, that was one of the toughest things I ever had to do, was try to get past that doctor to go talk to her. I was on the selling side, I was the listing agent, but the poor buyers, and thankfully the buyer's agent was a good friend of mine. So we were working our way through it. And we were just kind of saying, all right, trust me, but she could have changed her mind. Things happen. And that's what contracts are. And it wasn't valid until everybody signs it. All of the sellers have to sign and all of the buyers have to sign. So if there's 5 buyers and 5 sellers, they all have to sign. Unless they have an LLC and somebody has signature authority, or they have a corporation and somebody has signature authority. But if you're saying 4 people go buy a golf condo and then decide to sell it, we need signatures of 4 people. Try to round them up. It's like herding cats. All right, very quickly on assignment and novation, and then we'll move on. Assignment says that I'm in a contract, and let's say we'll use the same scenario, and James, I don't think minds, and Reagan doesn't mind being James's broker. But I'm working for Tyler, and all of a sudden Tyler decides that he doesn't want to buy it anymore, but Lily wants to buy it for the same deal, same price, money, motivation, everything. So what we can do is we can assign that contract as it was from Tyler to Lily, as long as everybody agrees. Now, Lily would be responsible for paying that, but what would happen is that Tyler would hold first responsibility in an assignment. If Lily decides that she wasn't going to pay for it, Tyler's still responsible because he's got the assignment, right? He assigned it to her. If we decided the best thing we could do is novate, a novation would be, let's take Tyler completely off of this and let's do a new contract using Lily. We'll keep the same dimensions. We'll keep the same, all the same money, same everything. But instead we're going to use, we'll put Lily's name as the buyer versus Tyler's. And now Tyler's out of the picture altogether. Lily has the new contract. It's as if Tyler wasn't in there at all. Okay. Is assignment actually used? It's not used as much because the banks have usually have put a big kibosh on loan assignment, things of that nature lately. They want to do so. You'd have to go through a few hoops to do it. So technically, no. Is it available still? Yeah. But because the banks want to qualify everybody, maybe Tyler's credit is a little bit different than Lily's. Maybe Tyler's rate was better or whatever. They won't just want to give an assumption to Lily. They want to see if Lily's going to be able to pay the bill. So they won't allow it. So that's usually where we end up with the heartache. Not so much that one party or the other. James just wants to sell his house, right? Find me a qualified buyer. That's all he's interested in. Reagan's just kind of going through and saying, Sam, what the heck are you doing to me? And I'm saying, all right, just hang in there. We're going to get this thing worked out. But then, maybe will the bank let Tyler give his loan to Lily? I don't know. Will Lily be able to grab James's assigned loan? I don't know. It's up to the bank. Still perfectly reasonable. We could do it. Doesn't mean it happens a lot.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.